you know, one of the things we always have to do is define who the client is. But in our field, we're often working with not just the senior, but the helpers of the senior. And very frequently, seniors will come in to interview with us to have an initial consultation, and they don't want to come in just by themselves. They want several people in the room to hear what's being said, to be able to try to understand it. And a lot of people haven't dealt with any of the topics that we're dealing with ever in their lives, and they may not have ever met with an attorney since they bought their home in 1951 or something like that. So, and they might not have even had an attorney involved much at that point anyway, just because things were different the way real estate transactions were done. And maybe they've settled their mother's estate or something like that sometime along, but times have really changed. Things are much more intense now in terms of legal requirements. And so people will come in and they'll really want to have their family unit there. There's also a dynamic that parents don't want to make anyone feel that they're being treated differently among the kids.
Yep.
And so they'll, even though we really only need to have this one person who's the primary helper, they will want to have the whole group there, even though sometimes that is awkward because people have had to come across the country to get to the meeting. And we basically have to have a pretty substantive meeting because people have traveled, and it's not uncommon for us to have a meeting the last day that the family is all together. It's like they got here for Christmas, for example, or someone's birthday, or whatever the reason is. Might have come for a grandchild's graduation, and they realize that dad is not doing very well and is not following conversations and is, that things have really changed since last holiday last year. And so they'll call and make an appointment. We have to do a conflicts check, but we can get them in a couple of days. And so sometimes it's the Friday before the kids are going to be departing on Saturday when we have a meeting. And then it turns out that there's a whole lot that needs to be done. And because very frequently people don't have anything in place.
I can see the value in that because and I used to practice this when I used to do this when I was in sales management. Speak to the group. Don't count on the group being able to communicate with them among themselves what was said. Mm-hmm. Because with the best of intent, whatever they're trying to pass on, even if they intend to pass it on as truthfully as they possibly can, something gets misinterpreted.
Exactly. Yeah.
So it's better to have all the people listening to a person such as yourself, laying out the inner workings, you might say, all at the same time.
Right.
So that they're all hearing the same word. And even with that, they will get some misinterpretations.
Right, exactly. At least they've got a greater chance that someone's going to remember what was said. But we all hear things through our own filter of what we thought was being said, and what's this guy talking about, and stuff like that. But anyway, it is an interesting process. The whole intake process. We do a screening to make sure that we and our community relations manager, Joyce, does the initial intake to find out what is this call about. If it's something that we don't do within our practice, then we refer it out to someone else, and because there's no point in wasting anyone's time, and we don't want to get kind of sucked into doing things that we don't do, because there are so many specialties, and we're kind of the brain surgeons of elder law around here. And I don't mean to over aggrandize it, but we are specialists, and this is what we do, and so it's important that we not take on a dental case when we're the brain surgeons. Exactly. So and so it's we do within the fields that we're working with in estate planning and long-term care related planning, special needs, guardianships and conservatorships, probate estates, and things like that, trust administration. Sometimes it's just some little piece of that. Very frequently a care agency like Comfort Keepers or Home Instead Senior Care will refer someone to us to get a power of attorney, because they realize that nobody has a power of attorney for the person who needs to have care, or maybe a power of attorney and an advanced health care directive, which is an important part of having someone be able to help you with medical decisions. So the case will come to us for that, but then it turns out that there's nothing else in place either, and so we've really got to educate the family about what needs to be done and what the opportunities are to protect some assets and that sort of thing.
Yep. Now, in general terms, what would be the piece of advice that you would give to people relative to the importance of having a will? When should they be thinking about having a will done?
Mm-hmm. Well, the first time, actually, really as soon as they're adults. So really, as soon as someone is 18 or more, they ought to do at least a simple will, and because none of us know when we might become disabled. I'm, a very fortunate person in that I fell asleep at the wheel and had a head-on collision in 1993. I had decided to go to law school, but I hadn't yet applied. I had taken the LSAT, but I fell asleep on the way home from the hiking trip in the White Mountains. And I could be dead very easily, or I could be, brain dead or something like that. Fortunately, no one in the other car that I hit died, but it was not a good thing. Mm-hmm. But that happened in a flash. Really, it was just an instant, and everyone's involved had a change of their life that quickly. And so it's important to have a will. Now, it could be that your assets are set up in a way that it doesn't go through the will. So for example, if you have your accounts in joint tenancy with someone and your home in joint tenancy, mm-hmm. and everything is set up in joint tenancy, or maybe a beneficiary designation if you have an IRA or life insurance, yep. and goes by beneficiary designation, well, there might be nothing that has to pass by will. But even in situations where people have everything structured so that they're essentially avoiding probate, having nothing passing by will, something can happen. So, for example, there can be a litigation judgment, or you might inherit something from someone, and that comes into your own name, and now that passes by will. And so it's important to make your own choices, and you get the opportunity to decide who you're going to leave things to, and for example, if all your loved ones have passed away by the time you pass away, who would be your what we call remote contingent beneficiary? That would be, do you want to leave things to your more remote heirs, your next of kin, that might be cousins or second cousins or something like that? Or do you want to leave it to charities? So you could leave your whatever you've got to your church or your synagogue or your college or your high school, or the American Heart Association, or, yep. Cancer Society, or the MS Association, or Alzheimer's Association, anything you want. And you've got the opportunity to do that. I'm actually doing some talks next week on estate planning in Kennebunk, sponsored by the American Heart Association. And they've done all the organization. These are next Thursday. One's at Atria Kennebunk in the afternoon, and then one's at a school in West Kennebunk in the evening, or at 5:30 actually. One of the points I make in that talk is we go through all the different pieces that everybody should have: a will, power of attorney, advanced health care directive, and I encourage people to have what's called a HIPAA authorization. That's a medical release form that names the people who your medical providers can release information to about you without violating the law. So you're naming people who are called authorized recipients of your health care information. That's beneficial. So for example, if you have a relative who, say a central family member, a daughter or something like that, who lives halfway across the country, and that person wants to be able to call in and find out how you're doing in the hospital doesn't then have to say, I'm sorry, we can't tell you anything about our patients. And even that you're there, not to mention that you've come out of surgery okay. That HIPAA, the Health Insurance Portability and Accountability Act of 1995, has imposed or created some medical privacy rules, and we all are entitled now to privacy as to our non-public medical information. And the fact that we're in the hospital is among those things, but it's also about your diagnoses and those sorts of things. Yeah. So those 4 documents are important. And I mentioned, so we all should have a will, and really it's as soon as we're old enough to be adults, we ought to have one. But the next big thing is that people will do wills when they have children, if they have children. So we will sometimes be dealing with people now in their 80s whose last wills were done when their children were born 60 years ago or 55 years ago, and their wills are pretty old. And there are different considerations now that need to be taken into consideration. Of course, the fact is, probably those people had maybe they had a home, maybe they were renting. The numbers were a lot smaller in the 50s and 60s than they are today. And so it's important to have a will that reflects what's really important. And one thing that we always do in our wills and trusts that we prepare is to include a provision that's called a contingent supplemental needs trust. Now, a special needs trust and a supplemental needs trust are the same thing, but in terminology, we call a special needs trust that's in another document a supplemental needs trust. This is just our nomenclature, and a lot of the elder law attorneys around the country use this same approach. And so all of the wills we prepare have a supplemental needs trust provision, and it may be very short, or more often it's about 4 or 5, 6 pages, something like that. And we prepare all these documents with software, so we can choose different variables and they get merged into the document. But we want to make sure that when people sign a trust or a will, it's protecting the beneficiaries from being thrown off of their benefits if they happen to be disabled or disqualified from their benefits. So if someone's will were not to leave things in a special needs trust, and say, for example, the person receiving a share of the senior's estate. So say someone dies at age 92 or something, and their child is 56, say 66. You you can't create a special needs trust for yourself if you're over 64. So if you're 65 or older, you can't create a special needs trust for yourself. Otherwise, you can if you're younger, and it does have some extra wrinkles in it compared to if your parent had put the special needs trust in their document. So we just strongly, strongly encourage that everybody's will contain a special needs provision for whoever might be a disabled person in the future. A lot of people will say, well, we don't have anybody disabled in our house, in our family. Yeah, but anyone can have a car accident today, so someone who is not disabled today might be tomorrow, and you can't predict these things. So I really encourage that. And so when people have children, they should do a new will. It's really a good idea when they have any substantial change in their family circumstances to look at their plan and see if it's appropriate.
And speaking of wills, can we talk a little bit about living wills?
Yes, yeah. Living wills are, in some cases, they are a separate document. In Maine, the more common way to have the living will provision is within what's called an advanced healthcare directive. And that's a combined document. It contains a healthcare power of attorney where you're delegating to certain people the ability to make medical decisions for you if you can't make them yourself. In that particular provision, I want to make sure that it goes into effect when you sign it, rather than having to have a determination either by a doctor or the probate court that you're incapacitated. Because very frequently people need to have someone else helping them make decisions, medical decisions, even though they aren't incapacitated. And they might just be asleep, for example, and preparing for surgery. And you want to be able to have your daughter or son or husband or whoever it is be able to sign authorization for you while you're ready to, while you're in prep, for example. So I encourage people to have the healthcare power of attorney go into effect when you sign it, basically. And then the living will portion in the Maine Advanced Healthcare Directive is called end-of-life decisions. And what it's addressing is if you were in a persistent vegetative state, that means you're brain dead, so to speak. You have characteristics where your body is on autopilot at this point. The brain is running it, but you're not really there in terms of being able to be cognitively involved in things. Another is to be in what's considered an irreversible coma. That's something different from being in a vegetative state. But an irreversible coma is it's a medical judgment whether you're in that situation or not. And of course, sometimes, rarely, but sometimes people do come out of irreversible comas, so it's not truly irreversible, but we can't control it, and for as well as the doctors can predict, you're not coming out. Well, in that circumstance, or if you're in a terminal condition, that is, you're characterized as, or your prognosis is that you're not going to live more than 6 months, very often because of cancer. If under those circumstances you need to, under any one of those circumstances, would you rather be allowed to die naturally or to be kept on life support systems that just keep your body running?
Back when my father had a stroke and ended up passing away, but that's a decision that we had to make.
Yeah. And it's a hard decision. That's
very
a big
difficult.
burden to put on people. I really encourage people to make that decision themselves. If they're doing so in general, they're not necessarily in that circumstance now. I mean, sometimes people are making these decisions when they know they have a terminal diagnosis, but obviously they're not making this decision when they're in a persistent vegetative state or a irreversible coma. But you're basically saying, if I'm in one of those situations and the only way to keep me alive and to extend the process of dying is to put me on machines until eventually I conk out, let me die naturally and keep me comfortable, but don't keep me alive for 12 years on a machine. And you know, there are situations where people can go a very long time. Now, another question has to do with tube feeding, called artificial nutrition and hydration. That's a little harder for people because they say, well, you know, please don't starve me. But on the other hand, sometimes people will just be on tube feeding, and that's the only thing that's keeping them going. And a lot of people used to have a hard time with this until the Terry Schiavo case, which was 10 years ago, in March of this year, 10 years before. And Terry Schiavo was 26 years old when she had a food allergy reaction, and she went into a persistent vegetative state. Her parents were watching her. You know, they'd visit her all the time, and this was in Florida. The parents were visiting all the time, and she was grimacing and making gestures with her face, and they thought that she was in there, you know, and then more like a stroke victim who was alert inside and impaired on the outside. As it turned out, in retrospect, after autopsy, the parts of her brain that control voluntary decision-making and things like that were gone. They had atrophied away over the years. But anyway, she was in that persistent vegetative state for 15 years, but because she started at 26 and died at 41, and it had to go all the way to the U.S. Supreme Court to get a decision, because the husband wanted to let her go. He said, you know, she would never want to be in a nursing home bed for 15 years and maybe more. And her parents said, but she's, you know, she smiles at us. And, you know, anyway, it was a very hard thing. Both sides had good reasons to make their decisions, but she didn't have an advanced health care directive. Had she had an advanced health care directive, she would have been able to be let go earlier.
Do you have any sense of, generally speaking, how many people have an advanced health care directive?
Well, unless they've been in the hospital and someone has, a social worker, for example, has encouraged them to do one, most people do not. It's very rare that people coming into our office have them, but sometimes they do, and if they do, they're usually maybe 1 year old because they just had an episode of some kind where they did it. Now, we've just actually changed our form for the last 12 or 11 or 12 years. I've been using a form that is a lawyer-drafted form. And what's happened is that we're now in the second generation of a form that the Maine Hospital Association and DHHS and a few other agencies put together, which is the same information, but it has been put together in a way that stakeholders agreed was very clear. What we have learned in our elder law bar, we have the bar being the lawyers. We have a section of the elder law of the Maine State Bar Association called the Elder Law section, and we had a big discussion about this on our listserv about 3 months ago in anticipation of National Healthcare Decisions Day, which was April 16th. There was a big push on for all of us to go out and do presentations on that one day all across the country. And the American Bar Association and other organizations were very much involved in this. So we were talking about what we used for our advanced healthcare directive. And some people said, you know, we've been talking a lot with doctors, and they would prefer that we all use the standard form that is downloadable from the DHHS website. And we decided as of that day we would switch over. So starting on the 16th of April, we've stopped using our prior healthcare directive, except for people who already have it, and we'll update the addresses of people or their phone numbers and email addresses and things on that form. But if they're willing to take a little extra time, we'll switch them over to the new form, which is not new for everybody, but it's new for us. But it's the one that actually, if you're at a hospital and they give you about a 14-page or 16-page form, that's the one that we use now. We have our name at the bottom of it, just say courtesy of Maine Center for Elder Law. But it's the same form. And the benefit of that for the doctors is if they're looking for a certain provision about, for example, end-of-life decisions, and they know that that's on page 6, they know where to find it, and it's not going to be written in some different way or buried in the document somewhere. I would encourage people to start using the standard form, standard Maine Advanced Healthcare Directive, just because we've learned that the medical community prefers it. And this is all about making good decisions and knowing where the information is. I'm just going to mention something else before you shut me off here, and that is what happens if you are in a situation where you're traveling or something and your advanced healthcare directive is back at home or in your safe deposit box and it's Saturday night when you have a car accident. Well, there are a couple of services now where you can have your medical directives so that you can access them 24/7. And that is, there's one called DocuBank. I've been using them as a service since 2000. And another is Advanced Directives, I think it's called. And these are services, both of which we use, but we've been with DocuBank longer. And we scan the documents that the clients have signed, and then we send them by email to DocuBank, and the client gets a little card that goes in the wallet next to their health insurance card. And that way it says, "Dear healthcare provider, if I am in your facility or under your care, I'm instructing you to contact DocuBank either online or by an 800 number and get my advanced healthcare directive." And that way you can download it.
I think we're being signaled.
We're being beeped.
We're being beeped, yes. Attorney Marty, pleasure.
Oh, thank you very much.
And I'm sitting here thinking in the back of my mind, and way back in the mind, thinking about when am I going to get you on again?
Okay.
There's a lot more.
Yeah,
there's a lot more to talk about.
Oh, yeah, and we can narrow the scope and talk about just sort of a brand.
I just scanned through your brochure while you were speaking, and VA benefits, and we've seen VA in the news quite a bit lately.
Yeah. Yeah, there's a lot to be
Affordable
talked
Care
about.
Act and what impact that might have. In any event, folks, it's been a very informative discussion today. I value it greatly, and I value in advance having Attorney Wallner on again in the near future.
Great. Well, it'd be my
Next
pleasure.
week, tune in. We're going to have the Commissioner of DHHS, Mary Mayu, on as a guest. I'm honored to have. She's going to be on for the third